All right, I think we shall now officially kickstart. Hopefully all of our delegates will return into the venue. We're now going to begin our next session, which is titled AFSA at 30, Founding and Growth. Now, this session reflects on AFSA's journey, its development, and of course, its future direction. So please help me in welcoming to the stage, and they are already on the stage, so I'll introduce them. Our moderator is Professor Michael Katz, Chair of ENS Africa, and our panelists for this session are Advocate Michael Kuper, SC, Des Williams, Deline Bierkus, Susan Mutangadura, as well as James Banda. Please give our panelists and our moderator a very warm welcome.
I think most of our audience are still eating their hamburgers.
Wait 5 minutes.
Sure, once we get started, there's going to be a stream in.
Let's give it 5 minutes.
You can see.
Okay. Streaming in. People, if you don't mind, can we wait 5 minutes to give people an opportunity to come in?
Later.
Good afternoon to everyone. We're going to start. So just one or two quick words of introduction. Thanks to AFSA for inviting me to moderate the session. It's a great privilege, and particularly on such an esteemed panel. If you don't mind, now and again I'll intersperse some personal observations, but let's get on. And to Michael Kuper, I remember your telling me that AFSA started with a phone call, and so far as one can put a date on it, that phone call would have been somewhere June 1996. Do you remember?
Well, yes. Yes. It's perfectly true.
Forgive me, I made one mistake, forgive. The CVs of all the panelists are in your papers, so we don't want to spend time doing that. But all of you know Advocate Michael Kuper, Mr. AFSA. So, Michael, please carry on with the answer.
Talking about this phone call. I was, at that time, the chairman of the Johannesburg Bar. And I had a phone call from Mervyn King, who was at that time the chairperson of the South African Chamber of Business, SACOB. And Mervyn had always been a protagonist of arbitration. And you must remember, at that time, there was no administered arbitration in South Africa. The only arbitration was ad hoc arbitration. And Mervyn was a protagonist of arbitration, and he saw in the business world the great need for it. So he phoned me, and he said, would the Johannesburg Bar want to participate in this arbitration initiative, which would lead the bar to a new work stream? Now, to tell the chairman of the bar that there's a prospect of a new work stream is like offering a ravenous wolf a rather large lamb chop. So I said yes. We were prepared to assist him in this initiative. Now, Mervyn had at that time already recruited a lady, Frances Turton, who had come from the Pretoria University and who became our first CEO of AFSA. And it was she who created and strengthened a relationship with the University of Pretoria, which has always existed in the entire AFSA history. So now, we had said yes, and very fortunately, we made two decisions which we didn't realize, I didn't realize then, how fundamental they were. But the first decision was that the Johannesburg Bar could not do this on its own, and that unless it recruited in support the lead attorney firms and the lead accounting firms and the lead stakeholders in arbitration, it was not going to work. And Michael, I think you might remember the very first meetings we had with the lead attorney firms and the like at what was then, what is still, I suppose, Innes Chambers, going back to 1995 or 1996. And we put to them the proposition that it was time for the legal and accounting professions to answer the Chamber of Business by providing an administered arbitration service. And it remains the only administered arbitration system in South Africa. But attorneys being attorneys, if I may say so, at that meeting, I told them how great this was going to be and how they must all join up. And they all were enthusiastic enough. But then one attorney in the front, very well-known chap, who I will refuse to reveal his identity unless you offer me some inducement, but he stood up and he said, "I've listened to you." He said, "I've got one critical question that goes to the heart of this." He said, "Why do silks charge so much money?" Well, so it wasn't what I thought was the basis of the discussion. But nonetheless, they came in and they supported the project. And without them, it would have been impossible. So AFSA was started as a result of a phone call on a non-profit basis with the membership of AFSA consisting of the lead attorney firms and the other stakeholders in arbitration. And the next step was to announce this project. And we were fortunate in November 1996, when AFSA was inaugurated officially, that we could have the unqualified support of the Minister of Justice, Dr. Dalla Omar, who was the first Minister of Justice in the constitutional dispensation. And it was vital because there was opposition to the idea that these lawyers should come together and start an arbitration project and facility. There was this opposition, and it was so important that, if I may, Michael, I want to remind you of something that Dalla Omar said there. He said, "Business has a right to note that there are legitimate mechanisms in place through which disputes may be resolved effectively, efficiently, speedily, and in the most economical possible way. AFSA will fill this void, and I wish it every success. We should devote our collective energy to ensure that the AFSA project is a success and becomes a component of a larger version which ensures that all South Africa's people will enjoy access to justice."
So, Michael, just on a personal note, I listened intently to the session before ours and all the virtues of arbitration expressed, and I thought Judge Sutherland's analysis of the arbitration in the jurisprudential ecosystem was really admirable, and all the panelists spoke about the virtues of arbitration. There's just one that I want to mention that made me such a supporter of AFSA. As a practitioner involved in international contracts of a lot of financial dependency, the perennial question was, which is going to be the governing law? And we said, it's happening in South Africa. And they said, but how do we know your judicial system? And the foreign lawyers are always saying, but let's go abroad to the international arbitration, ICC and that. And we were then able to say we had AFSA, a structured arbitration platform and system, and that was a great contribution to the practice of law in South Africa, that we could enter into international contracts governed by South African law, and there was an established arbitration platform. So Michael, to you and the founders, we'll still give our due praise, but this really was just one other personal. I'm part of a project now with Treasury and looking to make South Africa a synthetic financial center along the lines of Dubai, Singapore, and we are showing all the attributes we have in South Africa to do that, changing some of the financial laws, but that we can also parade a very well-established functioning arbitration mechanism will lead very much to the popularity of that system. So the legal framework within which AFSA had to work was antiquated. The sole piece of legislation dated back to 1965, and it was an act which in turn dated back to even earlier piece of legislation lifted from the archives of the UK. How could AFSA compete on an international level in those circumstances? No one better to tell you that than Des Williams. Des, over to you.
Thank you, Michael, and thanks to Michael Kuper too for just taking us very briefly down that 30-year road, a trip down memory lane. He mentioned about Francis Turton, and many of us will remember that the arbitration room was called the Francis Turton Room. And we were very proud of it. It was a real state-of-the-art facility. Now, what was state-of-the-art about it was that you could move the furniture around and arrange it whichever way you wanted it to be arranged. And that's as far as it went. That was a real state-of-the-art facility. But it was great. Now, Michael Katz has mentioned 2017, the enactment of the International Arbitration Act. And that was a major development, a positive development in South Africa through AFSA as the leading arbitration center in the Southern African region. In 2017, so it was in the year that the International Arbitration Act was enacted, I was invited to speak at a SADC Lawyers Association conference in Botswana. And it was at that conference that I met one Stanley Nyamanhindi. I'm not sure where Stanley's sitting, but he's here. Yeah, there he is, yes. And Stanley at that time was the chairman of the SADC Lawyers Association, so representing all 14 or 15 countries within the SADC region. And we had a long and interesting discussion about and shared a lot of stories about the frustration felt by many lawyers in South Africa and elsewhere in Africa when international commercial disputes were being taken to London and Paris to be resolved under the rules in organizations like the LCIA and the ICC. Africa was excluded from all of that. The lawyers were usually lawyers from London or from Paris. The African lawyers were not involved. We realized that with this new act it was possible to do a lot more. One thing led to another, and Stanley eventually came here, met Michael. We quickly established the AFSA SADC division, and we had a conference in Vic Falls. That was a very important step where we all got together and the AFSA SADC division was born. And a number of African lawyers, SADC lawyers, joined us on that occasion. Amongst them, Susan and James and a whole number of others. And we signed a memorandum of association, and the parties recorded their commitment then to the development, strengthening, and enhancement of alternative dispute resolution practices modeled on AFSA's services in the SADC countries by way of a joint initiative between the Lawyers Association and AFSA. And it's been a long and interesting road since then, leading to the signature of the Africa Alliance Charter at Johannesburg Arbitration Week 2 years ago. A number of you might remember that, and you may have been present on the occasion. The purpose of the Charter was to establish a member network of institutions committed to excellence in the provision of arbitration within the region, based on AFSA rules. By 2025, it had become apparent to the committee that it was important for AFSA to establish a permanent presence in some SADC countries, and that this was could best be done by the establishment of a dedicated AFSA-branded office in partner countries to serve as a focal point for arbitration and mediation services. This growth strategy was approved in November last year, and in the past few months, there have been discussions with a view to concluding alliance partner agreements with a number of SADC member countries. So yes, it's all a work in progress, and there's a long way to go. But with time, there will be dedicated offices in various African countries. There are a number of key issues that need to be looked at. They include education and training, the development of pools of arbitrators in those countries. Very importantly, making the countries seen to be arbitration friendly. There are still some African countries that have not signed the New York Convention, for example. That simply has to happen. We've been trying to get that message through, and we've succeeded. A notable case was Malawi, for example, which now has a modern International Arbitration Act and has acceded to the New York Convention. And hopefully we'll soon get there with countries like Namibia and others. But I don't want, I'm going to leave it to Susan and James to tell you more about what's actually happening on the ground and what the issues are there. Thanks, Michael.
Thanks, Des. I'd like to now ask Delene, who is the CEO of the China-Africa Joint Arbitration Center, to deal with what has become the long-standing association between AFSA and its partners. Delene?
Past that you might enjoy. For those who are not familiar with CAJAC, let me briefly explain. The China-Africa Joint Arbitration Center is a partnership between 6 international arbitration centers, 3 in China and 3 in Africa. All these centers are reputable centers. That is the Shanghai International Arbitration Center, the Beijing International Arbitration Center, the Shenzhen Court of International Arbitration, the Nairobi Center for International Arbitration, and the Organization for the Harmonization of Business Law in Africa, OHADA. This unique transcontinental initiative was established under the leadership of the China Law Society in answer to the need for a credible China-Africa dispute resolution mechanism necessitated by the increasing trade between China and Africa. This mechanism is acknowledged by the Forum on China-Africa Cooperation, known as FOCAC, a cooperative agreement signed by China and 50 African countries. CAJAC offers a set of rules, a uniform set of rules in both Chinese and in English. And the development of China, these rules were launched in 2022 after it was very carefully researched and signed by all the partners. But the development of CAJAC started a long time ago. As far back as 2012, the story of CAJAC began when the China Law Society suddenly contacted AFSA and said they wanted to visit AFSA. Well, the China Law Society in Beijing is the biggest association of jurisprudence in China, with at the time more than 150,000 individual members and equally impressive number of corporate members. So when the China Law Society announced that they would be visiting AFSA on a Sunday afternoon in December 2012, members of the management committee willingly gave up their Sunday lunches to meet with the China Law Society. The director of Overseas Liaison met with the delegation from AFSA. In 2014, as part of the Bridge Building and Cooperation Initiative, I was invited as the guest of the China Law Society. They were clearly interested in AFSA, and I had to speak at both Beijing and Shanghai. What surprised me was the extensive research that had already been done and how much they already knew about AFSA and dispute resolution in South Africa. Later that year, a delegation from the China Law Society visited AFSA to meet with senior representatives of legal firms and founding members of AFSA, and a memorandum of cooperation was signed between AFSA and the China Law Society. Another phone call. In April 2015, I received a phone call in Cape Town inviting Michael and myself to a meeting in Beijing to discuss a joint arbitration mechanism. In Beijing, there was great enthusiasm for establishing such a center, but it was Michael Kuper who had the vision to explain how this system could work in practice. AFSA and the Shanghai International Arbitration was appointed to establish such a mechanism. Now, we went to Beijing, we went to Shanghai, we met with the Shanghai International Arbitration Center, and we looked at each other, and we didn't know where to start. We said to them, in South Africa, we have an expression, how to eat an elephant. And they said, in China, we have an expression, every journey starts with a first step. And we took the first step. Back in South Africa, there was wide support for this international initiative, and in August 2015, the Johannesburg Consensus was signed in support of the establishment of KJAC. In March 2017, a KJAC delegation under the leadership of Judge Louis Harms went to Shanghai to familiarize themselves with the Chinese practice and procedure, and members of the Shanghai 14 offered invaluable support in the years to come. In November 2017, the first KJAC International Conference took place in Cape Town, a very successful conference. But there, it became clear that what potential users wanted was a uniform set of rules. The drafting committee for the KJAC rules and constitution was led by Professor David Butler, and his knowledge and insight was invaluable. Together we traveled to conferences and summits and spent many hours with KJAC partners developing the uniform rules and the constitution. And a great deal of this had to happen through an interpreter. When the process was completed, the KJAC Guiding Committee appointed Michael Kuper as the first chairman of the extended KJAC group. The Constitution provides for a shared panel of arbitrators nominated by all the KJAC partners, and it includes neutrals from other countries. KJAC is a unique service, offering disputing parties neutrality, speed, confidentiality, and the flexibility to resolve China-Africa disputes. We invite all the signatories of the Johannesburg Consensus, which you can see on the screen, and all the SADC alliance partners to include the KJAC Johannesburg clause in China-Africa contracts. KJAC will serve you well. Thank you.
Thanks, Delene. Very interesting. I think it's now time to get the perspective of leading practitioners from SADC, who also happen to be prominent members of the AFSA International Court and members of its panel. And I'm going to ask Susan Mutangadura of Zimbabwe and James Banda of Zambia for their views, not only in regard to AFSA in the last 30 years, but also their vision of AFSA going forward. So, Susan, you've got the mic. Over to you.
All right. Thank you, Michael. So I'm going to speak from the perspective of a SADC citizen, but also somebody who has worked in the business sector and who has also been subjected to court processes in circumstances where I realize in hindsight that the issues could have been dealt very differently under the auspices of alternative dispute resolution. And some of those experiences pushed me to want to investigate the use of ADR, greater use of ADR in my environment. And so I had the privilege in 2018, after embarking on a bit of a global journey, trying to study and understand arbitration from different perspectives, I had the privilege of sitting down to a coffee with Stanley, who, as Des has mentioned, was working with SADC. And I said to him, Stanley, you know, I've been on this journey, and I'm back home in Zimbabwe, and I would like to see ADR, and more significantly at the time I was more passionate about arbitration, flourish in our environment. And I know, having been in the business sector, this is really the tool that we need, and this is a tool that the business community requires. And so over that coffee, Stanley and I left with a very clear determination that we were going to play a part in whatever form, shape it came, to developing the use of ADR. The challenge, of course, that we faced was the realization that for ADR to work, for arbitration to work, we need a strong legal framework. We are very fortunate in Zimbabwe that we already had an arbitration act which is really based on the ancestral model law. So that we had, but also realized that we need strong institutions. And not only strong institutions, but a strong community of believers in arbitration. So the conversation started, and as Des has mentioned, fast forward 2019, I think was very transformational, because in Victoria Falls, the broader conversation about the use of arbitration began, and so began the journey that I was able to be on of the SADC alliance. So through this alliance, I think we have been very, very fortunate as the rest of SADC outside South Africa that we have AFSA. We can stand on a very strong foundation the legacy that Michael has spoken about and Des already. I think the path has been cleared. You know, I have the imagery of trying to set up a home in my rural village and having to dig up the trees and clear the space, but that has already been done for us. So we are so privileged that we can stand on this history, on this legacy, and not only that, you know, we're not talking about a legacy that has been created by people who no longer exist. We have the privilege of still having Michael Kuper and Des in the room and having the conversations and them telling us, you know, the pitfalls and the roads and the paths not to tread. So for me, I think, you know, we cannot be, as the rest of SADC, cannot be in a better position, and we do not have to reinvent the wheel. And we are fortunate that Des and Michael are so committed to walking every bit of the path with us. We have, at many of our meetings and many of the journeys that we take, we were in Namibia last year in November, again talking about the SADC Alliance, talking about the establishment of strong arbitral institutions, and I'm glad to see that Neliswa and the crew from Namibia are in this room today. And I was saying to Michael, wow, you know, you're still doing these long journeys and flying around, but he's there with us and really taking us through the processes. So in terms of the future, I see, you know, very, very, very positive signs. Because we also have a very vibrant community, I think, within the SADC region. We have a lot of enthusiasm, which is why I think this room is populated by, I think, you know, professionals from the SADC region. And we just need, I think, to harmonize, you know, like I see a vision of the rugby scrum, bring together, harness our strengths, and build the arbitral institutions that will take us to the future. And certainly sitting on that table, the international table, and that we will not be looked at as, you know, the guys from Africa, but the players from Africa, the arbitrators from Africa, the strong arbitration institutions that are reliable, that can be trustworthy, and that the international community can have confidence in. So I think just, you know, for a start, I would say that this is where we are. It has been a fantastic journey, a very interesting one, and also just to note, again, the contribution from AFSA that whilst we started with a committee that was sitting and trying to work out how we're going to break through into the rest of the SADC region, just last year at our last meeting, I think the recognition for the importance of this alliance was demonstrated in that the SADC, the AFSA SADC committee is now actually a committee of the, you know, the board, the main board. Again, just, you know, giving credence to the position that we hold and the support that we are getting from AFSA. So I think I'll say that. And of course, again, the positives, the future. Tomorrow, the ladies are going to have a ladies' breakfast. I think that, again, is testament to the positive steps that we are taking within AFSA to try and also just look at the diversity issues, which remain important, and a conversation that we continuously need to pick up. So I would say that, you know, in a nutshell, that has been my journey, an exciting journey, a positive journey with so much support. And I think the future is definitely very clear and very bright. I think I'll let James talk about the training and the other aspects that we are also looking into. Thank you.
Thanks, Susan. So, James, you've already been invited.
Yes, thank you. If I can just go back slightly to what Des had touched on. When you talk about AFSA's 30 years existence, inevitably you are led to who has AFSA partnered with over these 30 years. And one of them major institutions has been the SADC Lawyers Association. I had the privilege of being its president between 2016 and 2018. And a turning point in that relationship was obviously when we signed the MOU in 2019. But before that, SADC LA has always been known to be a strong defender of the rule of law, human rights. And we, of course, did that very well and professionally so. But we know that lawyers are involved in far much more than defending the rule of law and human rights. So the question was always, how do we get everybody else involved? Transactional lawyers involved in this matter, conventional lawyers involved in this matter, and that's where these alliances which we have with AFSA matter, because it is through those alliances that we started now bringing in professionals who are specialized in fields like mining, in energy, in arbitration. Des mentioned that he came in 2017 in Botswana when we had the AGM there. And before that, we had other trainings which were done to grill our lawyers or to expose them to issues which are paramount in their practice. Now, why is all this history important, and how are we seeing things going forward? When you analyze, if you take an example of what is happening, for instance, in the southern region, you've got new leaders who've come on the block, and they're talking about economic, they've got all these ambitious economic plans of what they intend to do in their countries. I'll give you an example of where I come from in Zambia. We've got a target, primarily our economy is based on copper mining. We have, right now, are producing close to 1 million metric tons of copper annually. The target in the next 5 years is to reach 3 million metric tons. In energy, we've got installed capacity of about 3,700 megawatts. The target in the next 5 years is to reach 10,000 megawatts to support this industrialization and to support the mining. And this is what you see happening in Botswana, everywhere else, where targets are being set around what are called critical minerals. With these industrialization targets, with these programs, economic programs, come commercial transactions. With commercial transactions, inevitably you're talking about disputes. And that's where, what we're talking about, the issues about Africa lacking capacity, the reasons why disputes were being exported elsewhere, disputes originating in Africa were being exported elsewhere, come concretize or crystallize at this stage when we look at what is happening in the region or in the continent generally. That we need to have these alliances. We need to be involved in these alliances with AFSA, in the region, in our countries where we come from, because we need to be ready and continue to remain ready and relevant as disputes arise. So what we're doing is, obviously, for you to be a skilled arbitrator, you need to have your primary profession, whether it's a lawyer, engineer, accountant, or quantity surveyor, whatever. But there are trainings also which you require. That is trainings in ADR, which we all have here. But over and above that, what we're emphasizing on now is the need to be specialized, looking at what is happening generally in the economies in the SADC region or in Africa. We've said there's trainings, the economies around in Africa, in the SADC region, are around mining, are around energy, they're around logistics, transportation, all these things. So over and above your primary training as a lawyer, quantity surveyor, your training as an arbitrator, what we're focusing on now also is getting you specialized so that when these disputes arise, inevitably which they will arise, you are ready to handle those disputes, and there's no need for these disputes to be exported elsewhere. So when we talk about, the conferences which we're having, taking you back again to the SADC Lawyers Association, you will see that the lineup of topics which will be there for those conferences will be around these specialized fields, getting you to understand what is happening in your specific countries, wherever you come from in Africa. So we will have, economists, we will have engineers, power traders, for instance, who will come and speak to you specifically about these economic issues for you to understand, what's going on, or at least to get you interested, for you then to specialize in this field. Because inevitably, as I have said, these things are coming. The politicians have done their part, and they are doing their part in setting these ambitious goals and clearing the way to ensure that Africa develops. Infrastructure in Africa is still low, and therefore construction will be is and will continue to be a very big field. Energy, the world is talking about energy transition. We don't even have energy in this continent to transition to something else. So all those things are things which we need to be prepared for, and which institutions like the SADC Lawyers Association, in partnership with AFSA, and the individual centers in the countries where you come from, which also have got bilateral arrangements with AFSA, are focusing on. So obviously the urge is for you to be interested in these things, get the calendars of all the trainings which are there, the workshops which are there, to get ourselves ready for the disputes which inevitably are coming.
Thanks, James. I would like to go to a different dimension. We've heard of the history, the origins, genesis of AFSA, its splendid track record to date. The question now is where to from here? And just before putting that to the panel, just one thought that I would ask you to consider in that is AFSA's work is in the private sector. A lot of the disputes we see today are in the public sector, regulatory bodies. And this seems to me to open an opportunity where you have financial legislation, financial markets, environmental bodies in the public sector. It seems to me that that would be fertile territory for arbitration under the auspices of AFSA. It would assist in unclogging the court rolls. B, there would be specialists that deal with these regulatory bodies. And I just want to ask, to start with you, Michael, seeing the role of AFSA and arbitration ahead, also to deal with this question I've posed, that isn't it time for AFSA and arbitration to start venturing into disputes in the public sector with regulatory bodies in mind?
Can I make a couple of points that seem to me to be challenges and prospects for the future, including what you say, Michael? The first is this. I want the SADC countries to receive the same quality of training that is available through AFSA locally. Because I want to see a generation of young people from the SADC countries coming together without the difficulties and the problems of the past, coming together as a new generation with strong ties with each other. I want to see young AFSA become the cement for uniting a young generation in the SADC countries. That will take training. That will take the need to provide for a roadway by which a young practitioner can not only be trained, but will have the opportunity of putting that training into practice. And that has been a huge problem that we have always faced. You can train the young practitioner, but then you find that the young practitioner's route into arbitration faces all sorts of difficulties and obstacles. And we need to plan for that, to have a roadway, which, as I say, can deliver not only the training, but also the reality of practice in arbitration. Then I want to see us taking our full and legitimate role in the global south. AFSA, with the incredibly valuable contribution made by David Butler, has created the rules and the protocols for China and for Africa, through KJAC, through FOCAC, to have a united front. And now that should be carried into BRICS. That should be carried into the global south. We already are negotiating with the arbitration bodies of the BRICS countries. Someone like Lindy has been deeply involved in that sort of project. It's got to be carried through. We've got to build on it. The global south includes Southern Africa. It includes a legitimate voice from SADC. Then Michael talks of the public sector. At this conference in Jaw, we will be signing agreements with AU bodies which carry with it a connection and an involvement into government, to make available to government in the public sector the availability of a trusted and efficient arbitral mechanism, so that when governments enter into intergovernmental arrangements, enter into arrangements with the financial houses of Africa, they do so with an understanding that there is a platform which is essential in making government have the same benefits as the private sector has in its knowledge and ability to use a body such as AFSA. And finally, I want to see AFSA strengthen its bonds throughout Africa. We have partnership arrangements with all of the brother and sister institutions of Africa. I want to see a stronger bond. I want to see more interchanges between us all. I want to see AFSA active right the way up Africa into KJAC, into OHADA, into North Africa, and down into Ghana and into West Africa. We are an institution that should be active throughout Africa. And we must draw up the plan, and we must implement the plans that will do so. And at least some of those basic agreements you will see signed here during JAW 2026. Thank you.
Thank you, Michael. Delene, any quick observations where you'd like to see AFSA going from here against its splendid track record?
I think that I'm not mic'd up. Thank you. At the last meeting of the guiding committee of KJAC, there was a need identified.
Is this thing on? Let's try the other one.
Thanks.
At the last meeting of the KJAC Guiding Committee, a need was identified to have a very active marketing campaign to make people aware of KJAC, the benefits of KJAC, and how it can be used to the benefit of Africa and to China. And I think that is a priority that we have to carry through in the near future.
Thanks, Delene. Des, any comment you want?
I think just one point to make is that when you look at the history of AFSA and say, if there's one factor that you would say led to the growth of AFSA, it was the success that AFSA had in getting AFSA arbitration clauses into commercial agreements. If I had to try and, if you were putting a percentage on it, I would say 90% of arbitrations that happen in South Africa start from an arbitration clause in a commercial agreement. Now, that's both a strength and a weakness. To have a situation where, as I say, it's 90% of it, and I might, it must be thereabouts, I would think. But when I say it's a strength, it's also a weakness in the sense of that it's difficult to then get into new areas where you haven't got that agreement in place up front with an arbitration clause. So when one's talking about the public sector, you then need to find ways to effectively achieve the same result. So in other words, it's got to be built in up front. It mustn't be something that happens only when the dispute arises, that parties then say, oh, well, we've now got a dispute, let's take it to AFSA and have an arbitration. There must be something to point them in that direction at an earlier stage. And that's, it's a tricky issue to address, but it's one that I think needs to be addressed.
Thanks, Des. Sue, anything that you'd like to add?
Is this working? All right, thank you. I agree with this. I think sometimes we have to front load, and I'm thinking, I don't want to mention which nation it is in case I get it wrong, but I think one of the African nations has actually either issued a practice directive or legislation for arbitration clauses into public sector agreements. So we might need to be thinking about that. But I think looking to the future of the AFSA SADC alliance, I'm definitely looking forward to a second half of the year where AFSA teams are going to be on the ground in the various SADC countries. I know we had a draft sort of like program that we'll be going out and doing some trainings. And I just really want to encourage my SADC counterparts to please take this on. Let's create a robust community of arbitrators and arbitration practitioners within the SADC region, and let's strengthen our institutions on the back of the support of the AFSA SADC Alliance. Thank you.
Thanks. James, 1 minute from you, because I've got something to do and we're running out of time.
Absolutely. I think what I would say is that it's quite important that we are familiar with what the AFSA rules say, with what the AFSA Charter is all about, and I'll explain why. We had a discussion, a negotiation on a power project in Zambia, and there was resistance in using the Lusaka International Arbitration Center. We recommended AFSA. We were familiar with it. The investor was not familiar, but when they read, they were happy that this is an established center, and so the dispute resolution clause remained where? It remained in Africa. It never went to the investor's country or anywhere else in Europe. And so that's what I would say. Let's support each other on this continent. Be familiar with what AFSA says, with what the Malawi Arbitration Center says, or Namibia or Zambia. That way, if there's resistance in using your center, your local center, then that dispute can be sent to another African center. But if you're not familiar with what the other center says, you don't know what the rules are, you've never experienced them, you don't know anybody, you don't know Michael Kuper, then there's a problem. So let's be familiar with each other's centers. That way, we'll move this continent forward. Thank you.
Thanks. So, just before we close, I want to make some remarks, and I hope you'll permit me to do so. We've heard today, not only in this session, but throughout, what AFSA's contribution has been to arbitration in South Africa. It started from nothing. We've heard of the journey that it's traveled, and it's been a splendid journey. I dare say that it's almost entirely attributable to my namesake, Michael Kuper. Michael has, keep your applause because there's a lot coming. Michael has been the inspiration, the visionary, the energy, the engine, the driver of everything you've heard and seen. And it's really no mean contribution. So I think that at this conference, it really is fitting that we recognize and applaud what has been done. There have been other role players, you've seen them, you've heard, but really the energy, the inspiration of what has happened in AFSA is Michael Kuper. So a big applause. Congress gave a bigger applause to King Charles than that.
Well, let me have a final word. The next jaw I want to see sitting here, not myself, not the elderly statesman of Africa. I want to see the young generation taking over the leadership of AFSA and carrying it into a new dispensation. Thank you.
So, to conclude, thanks to Des, Sue, Michael, James, Delene, very interesting discussions, and we've got 45 seconds credit. It's down to 40, so thanks to everyone for their attention.
Thank you.
Yep.
One more round of applause for our panel, wrapping up AFSA at 30, founding and growth, and some really powerful visions for the future. Thank you so much to our moderators and panelists. Ladies and gentlemen, it is now officially time for lunch. Yes. We will be taking some lunch in the foyer, and of course, we will return at 2 p.m. Enjoy, and we'll return with our next set of sessions after lunch.